Michael Murphy went in to pay his rent for October. In fact, let me back up. He had a pattern and worked it out with Nola Wade, who was the assistant in the office at RMA, to pay his rent twice monthly. He would pay every time he got paid, every 2 weeks. He'd go in and make a payment. So we know from that and from his testimony that he did it on a payday, and from the payroll records, or the pay records, that he gave the notice on October the 10th. If you'll notice, in the space up above, it rained from October 7th through the 9th. 3 days in a row it rained. We have AccuWeather reports that are part of the exhibits to the original motion. He goes in on the 10th and he informs Ms. Wade of this leak in the ceiling in his living room. And he shows her 4 pictures that he's taken. Now, these pictures are crucial because these are the pictures being relied on by the experts. They are also crucial in putting RMA on notice of what the defect was. There is 1 picture having to do with the kitchen and 3 having to do with the living room. He also, so he tells them October 10th, and Michael Murphy testifies that a day or 2 later, a couple of men from RMA came out to his apartment. One of them was inside the apartment in the living room. The other went up on the roof of the building with a hose and ran the hose for a little bit. They didn't see a leak. Michael is, in and around. He's not like paying close attention. But when they left, there wasn't a leak in the living room, nor was there a bubble. So it's presumed that they poked the bubble that's in one of the pictures in the ceiling. That's a bubble of water, right? They don't do anything more. That is the initial notice, and that is a totally inadequate response to that notice. No work order was issued. Ms. Prather was not personally notified of the complaint or the response, which was a divergence from their policy and procedure before that, as Ms. Wade testified. In November, Michael again goes to RMA. Now, in November, Nola Wade is no longer working at RMA. She quits the end of October. She's the one that was working with Michael about making his payments. Jared Cordova, without Nola Wade around, doesn't want to deal with that anymore and is insisting on full payment of the rent on the 1st of the month, which Michael can't do. They file a dispossessory in November. Michael settles it up. That goes away. But in the meantime, he has complained again about the leak in the living room with no response or acknowledgement from Jared Cordova or anybody else at RMA. At some point in this period of time, and we don't know exactly when at this point, but Nola Wade testified that Demetria Smith also complained about the leaks. And Nola Wade also testifies, even though apparently Ms. Murphy, Teresa Murphy, doesn't remember it, that Teresa Murphy complained about the leaks to RMA. We have no response whatsoever to any of those complaints. In December, Michael Murphy is going around again with the dispossessory and Jared Cordova, and they're not able to really talk about the issues. Michael decides he's just going to let the court tell him what he needs to do and let the dispossessory go forward, which it does. And in the meantime, he's trying to tell Katrina Prather that, and he sends her a text on December 14th that includes the 4 pictures that he took on October 9th, which show the bubble in the ceiling, the water on the floor in his living room, where the drywall tape is bulging from the repair that had been done before, and I'll talk about that in a minute. All of those he sends to her, and he's trying to reach out to her about that problem and about the fact that he's probably not going to be staying there much longer. She can't talk to him that day. The next day she calls and speaks to Linda Kendrick, And they create this work order on December the 15th, which has been quoted. But bear in mind that this is what Linda Kendrick says Katrina Prather told her that Michael Murphy told her. So we're 2 steps away from the person that made the original statement. The defense has repeatedly stated, and it's not accurate, that Michael Murphy in December was only complaining about a hole in the kitchen. If you check Michael Murphy testified, and it's at his deposition at page 62, lines 8 through 18, and page 63, lines 12 through 64, line 9, that he also talked to Prather about the leak in the living room when he sent the pictures on December the 14th, and he talked to her. So there is a big statement, I mean, big question of fact about that. But we have notice. We have notice multiple times. And the most important notice was the notice in October. That notice got some response, not a work order like it should have, not notice to Katrina Prather like it should have, because quite honestly, I think Ms. Prather would have done something about it. But RMA didn't. So, a landlord, and I'm citing to a case, Mason versus Gracie, which is 189 Georgia Appeals 150, a 1988 case. A landlord is liable for damages when the repairs he has a duty to make are completed negligently so that a defect in the premises remains despite the attempted repair. I think that's directly on point for what occurred in October. Again, this is citing Ellis v. Hartford Run Apartments, LLC, 335 Georgia Appeals 118, 2015 case. The landlord's failure to make repairs within a reasonable time after due notice is given renders him liable to the tenant for damages resulting from the failure to make such repairs.
Can I have that slide one more time? I typed it in wrong.
Yes, Your Honor. 335 Georgia Appeals 118. This is true even though the landlord attempts to make repairs, since he is responsible until the repairs are actually accomplished. And then the Stack v. Harris case, which is cited in our brief, 111 Georgia 149, when the landlord is notified that the premises are out of repair, it becomes his duty to inspect and investigate in order that he may make such repairs as the safety of the tenant requires. It follows, therefore, that when after such notice the landlord fails within a reasonable time to make the repairs, he is chargeable with notice of all the defects that a proper inspection would have disclosed. So we have this appearance of 2 RMA, apparently maintenance men, show up. One gets on a roof with a hose. One is on the side of the apartment looking to see if there's a leak. And they don't see an active leak, but they are not there for even 30 minutes. We get now to Mr. Dunn's testimony as an expert on roofing. Mr. Dunn has conducted hundreds of roof inspections for water leaks, including the type of inspection that apparently RMA was trying to do, which is called a water test. Mr. Dunn has some 25 years of roof contracting and consulting experience. It is his opinion that in order to properly conduct a water test like that, you would have to run the water for at least 2 hours and up to 4 hours, up to half a day. And then you might not still get it, but 30 minutes is not going to do it. And we're talking about less than 30 minutes. It's also his opinion, and this is in his affidavit more clarified in his affidavit, that the type of sealant that RMA repeatedly put on this flat roof that held water was not designed to be used for that purpose. That it would delaminate, that it would crack, that it would degrade, that water would get underneath it, would migrate to wherever there was a crack in this concrete roof structure. And there would be a leak, and there would be problems in the apartments below. And that's why you have to do a longer water test, because you have to give it time to migrate if the crack is not directly under where you're applying the water. So what we have here is we have notice, and we have a totally inadequate, in fact negligent response, and a failure to do the proper inspection or investigation to determine what should have been done. That would be the case if this had never been a situation that RMA had dealt with before. But in point of fact, and we go now briefly to the timeline, in point of fact, RMA had repaired the roof and the ceiling in the living room 4 times before it fell on Ms. Murphy in December of 2017. We go all the way back to July, and we know that a tree fell on Dia Fuller on the building. Now this again is a 3-unit, 1-story concrete block building with a flat concrete roof. And a big tree fell on the side, that was the side that Mr. Murphy, Michael Murphy's apartment was on, the 105 side. We know that because there was repair to the masthead that only appeared on his side of the building. We have, and I'm just going to stick to the repairs on Michael Murphy's unit, 1005. In April of 2014, RMA tore out and replaced the living room ceiling. Your Honor, for the court's convenience, I've just made copies. I want to apply the sources.
Thank you.
This is the general ledger from RMA. Sorry. So we see in April of 2014 that RMA tore out and replaced the ceiling in unit 1005. That is shown on page 14 of the ledger, which is part of what I handed you, the excerpts there. And I've highlighted those portions. I think it would be the last page, 14 to 16. You can see it's got an entry there. It says painting 1005 D.F. Fuller, paint all walls, some trim, tear out ceiling in living room, and put back on, etc. Again in April, then in May of 2014, RMA repaired the roof at D.F. Fuller with roof sealant. This is demonstrated on page 5 of the ledger, which is, the little pages are down at the bottom right.
I'm tracking you.
This is the 3rd page. It also shows you the maintenance there, where if you look at the top, on April the 4th of 2013, well, that's in the different unit, I'm sorry. So May of 2014, they've applied sealant. They did that after having to repair the roof in the living room of 1005. December of 2014. RMA patched the roof leak, patched and painted sheetrock in the ceiling of living room in 1005. This is page 6 of the ledger. December 24th, again, same month, 2014, RMA tarred the roof of DF Fuller to stop the leak in the bathroom of 1007. December 28, 2015, roof leaking in 1005 living room, mold getting worse. This is on the owner's report. The owner's report is one of the exhibits to our original brief in response to the motion for summary judgment. But it's at page 5, and the work order there is 11920. January of 2016, the next month after the roof leaking and mold getting worse in unit 105, RMA had contractors spread 3 buckets of tar, quote, silver fiber coating on the roof, and replace the living room ceiling that fell down in unit 1005. This is on the ledger at page 7. Then we get interesting. Where I go next, let me just point out again, what I think the court may recall. RMA, the management company, is owned until sometime shortly after this lawsuit was filed, was owned by Bill Jones Sr., Bill Jones Jr., and Jared Cordova. Prior to DF Fuller being sold to Katrina Prather in August of 2016, RMA was managing it for a company called BBJ Holdings, LLC. BBJ, Bill, and Jared. The same principles in both companies. So in January of 2016, after they have now repaired the living room in 1005 3 times, and put sealant on the roof 3 times, they seek a bid from a construction company, Absolute Construction. They seek a bid for roof renovation. This is Exhibit E to our original response to the motion for summary judgment. It contains 5 or 6 pictures in the original email. The email is one from Greg Pruitt to Jared Cordova saying, I'll get you a quote on this, tomorrow. And the pictures attached absolutely show water standing. In fact, it looks like there's almost an inch of water in one place where a ruler is held in the water. There was water standing on this roof at DF Fuller. The estimate that comes back again, Exhibit E to our original response. The estimate comes back, type of estimate, new roof, client Bill Jones Jr., Jared Cordova. Property address 1005, 1007, 1009, DF Fuller. Description, frame new roof over slab roof with wood framing, so new roof will have fall. 2, cover new framing with 29 gauge metal. Total cost, $10,935. So when the defense says, which they did in their briefs, that there's no evidence that water stood on this roof or that RMA was aware of it, it's totally false. They were aware of it, they got an estimate to deal with the problem and then didn't deal with it. What they did instead is put some more sealant on there and put it on the market. How do we know that? Because the appraisal report that Ms. Prather got when she bought the property closed in August. The appraisal report in July has a note in it that says This property has been on the market for about 90 days or less when he's out there doing his inspection. 90 days back from July, and you are what? May, shortly after you apply roof sealant to the building and after you've repaired the living room ceiling in 1005 3 times. So when RMA responded to Michael Murphy's complaint in October, they did so totally inadequately and improperly, with the knowledge that they had to repair this roof and the ceiling 4 times before Ms. Prather bought it. Now, it's curious and it's impossible to tell for sure because we're dealing with just general ledger entries and work order entries, and they're not, they're within a few days of each other because one reflects payment and one reflects when the work order was opened and this and the other, but we're still in the ballpark. But it appears that every time they put roof sealant on the roof, they had to replace part of the living room ceiling in 1005. It would appear that they didn't do the roof sealant until they had the ceiling collapse in 1005. So we're on a motion for summary judgment. Inferences are in favor of the plaintiff here because we're defending this motion. But the inference there is that they didn't do anything until they actually had a collapsed ceiling inside one of the units. So, October, now, let me back up. This is interesting also. Because in January of 2017, Michael Murphy, and they showed you the work order, Michael Murphy complained about mold in his unit. There was black mold all over the place. They issue a work order, they go out there, and they remediate that mold. It cost Ms. Prather about $1,200 to do it. And in connection with that, she asked Nola Wade, who was the one that had told her about the problem and what it would cost to fix it. She says, go ahead and fix it. But she wants to know what portion of the roof has been replaced and what units are under the portion of the replaced roof. To which Ms. Wade responds, and this is in January 10th of 2017, the roof, being concrete, has not been replaced. Just an exuberant amount of tar has been applied to stop leaks and prevent more damage to the units. At this time, we don't have any reports of the roof leaking, and any time we do, we apply more tar. This seems to work and stops the problem without replacing a concrete roof, which would be very costly. Every unit has had several applications of tar or quicksilver applied to it. So, Ms. Prather is being told that if somebody reports a leak, RMA will go and put roof sealant on the roof to keep more damage from being done to the units. This was their policy. This they had done repeatedly. This they didn't do in October of 2017. Aggravated by the fact that during that time, sometime during 2017, they changed their policy, they being RMA changed their policy about issuing work orders. Ms. Wade testifies that they were getting so many complaints when it rained that they stopped issuing work orders for complaints because it would just upset the owners and they had to deal too much with that. So they would just send somebody out to check on it. And if there had to be something done that they determined, then they would issue a work order and bring the owner in. They stopped doing that. And that's why no work order was issued in 2017 October when Michael Murphy complained. As I said earlier, if there had been one, I think things would have turned out quite differently here. But also, if RMA had done what they typically did in this situation, things would be totally different. Because we can see that even their Band-Aid, which really wasn't designed to last long, using the materials they did, according to Mr. Dunn, those materials wouldn't even been warranted for this type of work. If they had done that in October, Ms. Murphy was hurt in December, there wouldn't have been a leak. It takes a little bit longer than that, even on the past history here, for the sealant to start delaminating or cracking, or even if they don't cover the whole ceiling, to work underneath the portion that they had recovered. So we have a but-for situation here in terms of causation. If they had done in October a proper inspection, a proper investigation, and responded properly by doing even their Band-Aid repair, which in itself wasn't sufficient, as we know, because you got a quote for almost $11,000 to actually fix the problem. But even if they'd done their Band-Aid repair in October, or a couple of weeks from the time Mr. Murphy complained, a reasonable amount of time, which is, of course, up to the jury to decide what that would be, then more likely than not, we wouldn't have had this situation in December where Ms. Murphy got hurt. Your Honor, there's a case, Martin versus Johnson-Lemon, which is 271 Georgia 120, Supreme Court case, 1999, which has a definition of repair, which I think is illuminating. And it states, a repair contemplates an existing structure which has become imperfect and means to supply in the original structure that which is lost or destroyed, and may thereby restore it to the condition which it originally existed, as near as may be. We're dealing here, and one, I'm going to apologize on the one hand and just state that it's just kind of something we're all dealing with in this case. We don't have great pictures. I've asked for the JPEGs. I've gotten a few JPEGs, but I don't have them all. So when everybody complains about grainy pictures, these pictures almost exclusively came from the defendants that we're relying on. But they seem to be good enough for the experts to render opinions about what's going on here. That being said, I filed my own affidavit yesterday to add a couple of exhibits, which are documents, actually a couple of email chains that were produced in discovery. So I only did that because the pictures attached to them are pictures that are being relied on by the experts and by everybody in this case. Those emails identify when those pictures were made. So we now can trace back which each of those pictures was made. And the first set of pictures was a set that was taken by RMA on the morning of December 18th, the morning after Ms. Murphy was injured. Those are the pictures that show the hole in the ceiling, the condition of the roof with the cracks and the leaves and the water standing. And there is a shot up through the hole in the ceiling that shows the underside of the roof. So it's important to note that that picture was taken within 12 hours of Ms. Murphy's injury, or just about 12 hours later. But those are sent to Katrina Prather by 9:36 the morning, Monday morning following her injury on Sunday. Then we have another set of pictures in an email sent to Ms. Prather later in the afternoon. I think, if I remember, 12:36 p.m. in the afternoon, which is Exhibit B to my affidavit. Those are pictures of the repairs to the roof. So this roof is already repaired by 2 o'clock the next afternoon. Did not take them long to get out there and do what they had done 4 times before. So, what is a reasonable time for Tim to have responded? Of course, that is a jury question. But it's clear that if they put their mind to it, they can get this done in less than a day. If they had done that in October, we wouldn't be here. That point also goes to why neither of the defendants was able to see this building on December 17th or 18th. I mean, it just goes to, you know, I'm not at this point arguing an issue of spoliation, but by the same token, I don't want the defense to argue that you didn't get out there quickly enough to see what this was really like, or these pictures aren't good enough for you to render an opinion, and that's all we have to deal with. With respect to, and Mr. Dowling didn't really talk about it this morning, but it's in his briefs. With respect to his position, they sort of mentioned it, that Ms. Prather can't be held liable because she didn't know and she wasn't put on notice directly. That just ignores the law. And I briefed it, and I've mentioned it, but her duties are non-delegable. It's set forth in OCGA 447-2B2. Also set forth in the case of Gaffney versus EQK Realty Investors at 213 Georgia Appeal 653. So notice of the leaking roof and ceiling to RMA as Prather's agent for the managing property was notice to defend Prather. She can't dodge that. As a matter of law, she had notice. Your Honor, I don't know, I mean, they didn't mention it this morning, but you know, they've made an argument in their briefs, and they made it earlier about punitive damages. I would like to mention the case I cited in my response to the renewed motion for summary judgment, which was the Norfolk and Southern case, where, and I could pull up the site, but it's in the brief, where they closed down a certain easement they had, but when it rained, it flooded the neighbor's property, and they knew that, and they didn't do anything about it, even though the neighbor had complained and said, please do something about it. Finally, the neighbor sued them, and the court held that was sufficient to argue a conscious indifference to the consequences. That they knew of an ongoing problem, that they knew the consequences of the ongoing problem, and that they failed to do anything about it. That's what we have here. We have RMA knowing that this roof leaks, holds water and leaks, that they have had to repair it 4 times, that they've had to repair the ceiling in the unit where Ms. Murphy was injured 4 times before it happened again to her. That is conscious indifference to the consequences. And that is also attributable to Ms. Prather. by law. They made some points about Michael Murphy's reaction and saying, cool, no problem, that kind of stuff. I want to cite the court to another decision here. This is Garner versus Lamar, L-A, capital M-A-R-R, at 88 Georgia Ave, 364. And this deals with contributory negligence. It really deals with the awareness and knowledge of the danger. Interesting facts. Where the plastering of a bedroom ceiling in rented premises is filled with numerous small, lengthy cracks, and because of this condition, the dangerous condition of the ceiling is not perfectly patent and obvious, it cannot be said as a matter of law that tenants who continue to use the bedroom with knowledge of the cracks, but without knowledge of the dangerous condition of the ceiling, and who are injured by the falling of the plastering, are guilty of negligence proximately causing the injuries. In other words, there's a big divide between being aware of the defect and being aware of the knowledge of the danger caused by the defect. And they're talking about Michael. They're not even talking about Teresa, who has said, I didn't pay attention when I was in there on December 17th. Nor should she have to. Who walks in and looks up at the ceiling? They didn't address it again this morning, but in RMA's renewed motion, they seem to be trying to make this into a slip and fall case, which it is not. There is absolutely no evidence that Ms. Murphy's injury were caused by anything other than the ceiling collapsing. Tamika Threet is the only eyewitness, and she says the ceiling fell on her head and neck, knocked her down, and she hit her head on the coffee table. No evidence whatsoever of a slip and fall. Trying to shoehorn the case into the line of cases where if the plaintiff doesn't know what caused them to slip and fall, they lose. Which is a valid line of cases, but does not apply to this case. Your Honor, I think that there are 4 words in one of the defendant's briefs that tell the true tale about this whole motion for summary judgment. And those 4 words are, the only credible evidence. Once you bring that in, it's a jury question. It's a whole jury case. They may have a lot of things to talk to the jury about, but that's who they should be talking to, not to the court.
All right, thank you, Mr. Harris. Mr. Dowling, Ms. LaVorse, would y'all like to respond?
I guess I'll address the court real quickly. Oops.
The floor is yours.
No, I guess I'll sit if that's okay.
Yes, however y'all prefer.
Just let me know if you can't hear me.
I was gonna say, I think your mic is off. Just make sure it's got a green light on top.
The
There
point
we go.
is not
Can you hear me now?
to
Can you
hear
hear me
you,
now?
it's so that everyone can.
Yeah.
People can hear you,
It's like
that
I told
you can't even
Can
see.
you hear me now?
Yes. Now we're ready.
Or Verizon commercial or whatever. I'm not sure, Mr. Edwards meant to, but I think he literally just proved our point in his last statement. And that's that Michael didn't know about a patent defect, or a latent defect. He's like, he's saying, well, why would I be worried about it? I didn't know about it. Well, if Michael doesn't know about it, certainly RMA and Prather couldn't know about it. I'm not sure he meant to say that, but that kind of is the whole point of the case law we cited, that we have to be on notice of the defect. And here is the defect that caused the injury. As we said in our brief, we concede that we fixed the roof, But that's a good thing. We fixed the roof when it had a problem, and there is absolutely no evidence linking a roof problem with what happened to Teresa Murphy on December 17th. None. Zero. You know, Mike Dunn, it's interesting because I feel like I was sitting at a completely different deposition when Mr. Edwards was talking about Mike Dunn, because Mike Dunn conceded that he doesn't even know what kind of sealant is on there. Mike Dunn, I will admit, he knows a lot about roofs. The problem is he doesn't know anything about this roof. He's looked at pictures and says it's flat, and it looks like it has a sealant, and it looks like it has cracks on it, but he has never examined the roof. He has never been on the roof. He has never done any scientific testing on the roof. He has never been inside the building. He's never been inside Michael's apartment. He's never been inside the apartment, whoever owns it now. He's never looked at the ceiling. He's never done any testing. So he knows a lot about roofs, but he doesn't really know anything about this roof, and he certainly doesn't know anything about the condition of the roof in December of 2017. So I'm kind of segueing into our Daubert motion, but that's a huge part of why we think Mike Dunn shouldn't be allowed to testify. At the last minute, we deposed Mike Dunn for 4 hours. And at the end of the day, again, while he has a lot to say about roofs and, a lot of it was over my head, quite frankly, but when we really, got him to, when we really drilled down on his testimony, he basically said, I just know there were cracks in the ceiling and that there was water on the roof and the cracks were somehow in the same proximity of where Teresa Murphy fell. And I said, how do you know that? He said, because the plaintiff's attorney told me. That surely cannot be a basis for an expert's opinion. The plaintiff's attorney told me. Again, no testing, no examination, nothing. So we take his deposition for 4 hours. The day that the plaintiff files their responsive brief, we get an affidavit from Mike Dunn, shockingly, because he told us he had issued all his opinions when we deposed him for 4 hours. And he comes up with this, that RMA was doing some kind of water testing and they weren't doing it properly. No one has testified that they were doing a water testing. The only evidence is from Michael Murphy. He said there were 2 dudes on his roof. They put some water on his roof and it didn't leak. And it's interesting that this timeline says nothing was fixed. That's an absolute fabrication. It was fixed. Michael Murphy sat in his apartment and said it didn't leak. It didn't leak anymore. Whatever they did, they fixed it. So that's just completely inaccurate to say that it wasn't fixed. It absolutely was fixed that day. I don't know if I need to go. No one's really talked a lot about Mr. Caballero. He's a sheetrock guy. I don't think he really adds a whole lot. I'm not even sure the plaintiff is going to rely on him, but he basically says drywall gets wet. I mean, I think, a 10-year-old can tell you that drywall gets wet and then it may, corrode a little bit. But he doesn't seem to add a whole lot. But I certainly don't want you to get the impression that we are somehow waiving our argument that his testimony should be stricken as well. So they don't have any expert testimony to support this theory. All they have is conjecture and that a roof would be repaired and then in December, Teresa's walking under a ceiling and it collapses. But there's no, the problem is, Your Honor, that it's just this gigantic leap and it's not even a logical leap. There's no testimony about causation. There's no testimony about what caused that particular portion of the ceiling to fall on Teresa's head on December 17th of 2017. Nothing. And I also would point out, Your Honor, all you have to do is look at this graph and just, recount everything that's that everyone has been talking about this morning. Michael. This entire case rests on Michael Murphy's testimony. There is not a shred of evidence prior to Miss Murphy's accident on October of 2017 that there was ever a leak reported, that there was ever water on the floor reported, that there was a bubble on the ceiling reported, that there was a hole in the ceiling. All of that testimony is after this suit is filed, and it is 100% for Michael Murphy. And I will tell you, I don't say this casually, Michael Murphy's testimony is to not be trusted. His own deposition, which took forever, he can't even get his story straight in his own deposition. This graph says that Michael Murphy complained to Jared Cordova between November and December of 2017. Absolutely not true. Michael Murphy said in his deposition, I did not complain to Jared Cordova between November and December 2017. Because by then, Jared wasn't talking to me, I wasn't talking to Jared. Jared was trying to get me kicked out. I mean, his testimony is all over the place. You can't even pin the guy down as to what happened because he's making it up as he goes along. So then, 24 hours ago, or I guess maybe it's 26 hours now, we get an affidavit from Michael Murphy. Yesterday, this was filed, Your Honor. And I think it's because the plaintiff knew there were a few things they needed to shore up about this bubble and about what was happening in November. But Michael contradicts his own testimony. Paragraph 3, on October 9th, 2017, it had been raining for several days, and the ceiling in my living room at 1005 DF Fuller was leaking. I took several pictures on that day to show the condition of the ceiling and the floor in my living room under the leak. That is absolutely, completely adverse to what he said in his deposition. He said on page 65, I did not see water coming out of the ceiling in October of 2017. He also says, it's interesting, he says, again, the only pictures we have in this case were from those text messages that just, all of a sudden in December, he's showing Katrina these pictures in a text message, which he claims he took in October. But that's not actually true. He said the pictures were in his phone in October. But I asked him when they were taken, when did you take the pictures? I don't know, I'm not certain, I'm not sure. That's page 112 through 114. So now he's saying, I took the pictures on October 9th. I took the pictures on October 9th to show the bubble in the living room. I took the picture on October 9th, 2017 of the water on the floor of my living room. That's not true. That's when he says the pictures were in his phone, but he also said he doesn't know when he took those pictures. For all we know, they were taken in July. I don't know. But Michael certainly doesn't know. So Michael just can't be believed. He's all over the place. He can't get his story straight. And he's the one-on-one person who talks about anything remotely related to what's going on in this apartment. And he is literally the only person that they're relying on. Even their own expert relies on Michael Murphy, who again is not reliable as a witness. So I just point that out, Your Honor. There's, again, as Mr. Dowling said at the beginning, this is a lot of mud being thrown against the wall in an attempt to distract from the real issue in the case, which is notice to RMA and notice to Katrina Prather about a defect in the living room ceiling, such that that defect was the actual cause of Miss Murphy's injuries. And there is none.
Okay. Thank you, Mr. Morris. All right, Mr. Evers, anything else on this topic?
Yes, Your Honor.
Okay, go ahead. Floor is yours.
On causation, while it may be true that most of us understand that a leaking roof will eventually lead to problems inside the house or residence or whatever, Mr. Caballero, 22 years repairing sheetrock, mostly does repairs. That's all, I mean, the name of his business is Drywall Repairs. It's his opinion, from looking at the pictures, that the fallen sheetrock in the living room of 1005 after Mrs. Murphy is injured shows water damage. In fact, in his opinion, it's been there long enough that there is black mold forming on the side above the ceiling. It's also his opinion, based on the size of the piece of sheetrock that fell, that was a previous repair, because it's not a full sheet of sheetrock, and it shows evidence of a repair. It's also his opinion, and well, let me back up. Michael Murphy might not have been able to remember in his deposition, but in his text of December 14 to Katrina Prady, he says specifically, the last 4 pictures was took October 9 in my phone. So he says it there, at the time, contemporaneously with sending the text. So what we have is we have a place in the living room that, according to an expert, has been previously repaired. We have evidence that there have been 4 previous repairs to the living room in Unit 1005. I think the inference is easy to draw that that's where the repairs were done. We have a picture of the hole. We have a picture up into the hole showing a crack right above the hole in the ceiling, the sheetrock. You can see the crack. This is, how can I get you there quickly? If you look at Exhibit A to my affidavit, it is the fifth picture.
I have it pulled up.
Right? It's also identified as by Michael Murphy, who lived in the apartment, that reasonably and accurately depicts the condition of the roof, the underside of the roof, in the area where the ceiling fell down. So we've got causation, Your Honor. We have a leaky roof holding water. We've got a crack right above where the hole is in the ceiling after it falls. We've got an expert saying that this is evidence of a prior repair there. We've got proof of multiple prior repairs in that living room. We've got evidence of water damage to the sheetrock that has fallen. We've got testimony of water leaks being reported to RMA. And I will say this, for Michael Murphy to say that it didn't leak after the 2 guys came out and did their inadequate water test is not the same as saying that RMA fixed it. They didn't do anything. Maybe they burst that little bubble that's in the ceiling. And so it wasn't leaking then. But he very clearly testifies that it started leaking again in November. So it wasn't fixed. There's no evidence, there's no work order. If it had been fixed, there would have been a work order. They would have gone back and said, this has to be done, we need to notify Katrina Prather because we need to issue a work order, because buying this stuff to put on the roof costs more than $250, so we have to get her approval. Would have been a work order, there isn't one. We have causation.
All right, thank you. All right. And I've saved the notes in the highlights as you all have pointed them out, so that when I circle back to it afterwards, I can make certain easily find the pieces you appointed me to in your briefs. All right, so anything else on the motion for summary judgment? Before we pivot to the 702 motions?
Just on the,
Sorry.
just on the timeliness issue, I understood you were gonna just take that under advisement. We don't need to discuss that.
No,
You don't
I'll
need us to.
look at it. I haven't checked the dates. I really want to do today on the merits, and then if I look at it, it's egregious, then I'll address it. But I'd love to, I'd like us to stick to the merits
Yeah.
today.
Absolutely.
Okay, but it's just under advisement, so, okay. Which one, who do you want to address first? Mr. Dunn or Mr., sorry, not Cordova,
Okay.
Caballero.
Caballero, sorry.
I kind of already talked about Mr. Dunn, I think.
Yeah, that's why I was wondering, and,
Didn't have a lot to, I did want to say something about Mr. Caballero though.
all right,
It's interesting because, well, he talks about sheetrock and how it can get wet. And again, I'm sure you'll read the entire deposition, but at the end it was kind of interesting. I was kind of being, kind of tongue in cheek about it, but because I said something like, my kids had a dog and they would chew the drywall. And he's like, yeah, you can get holes for lots of reasons. Now, I'm not saying there was a dog on the ceiling, but the whole point, and I'm not trying to be flippant, but Mr. Caballero did not link this hole in the ceiling to a wet, to a roof that held water that then leaked and then caused this to fall. He was not at all certain how it fell. He wasn't certain how long the water had been there, if there had been water. I tried to pin it. He's like, I don't know. And he even asked me, he said, how long do you think it was there? I'm like, I'm not the expert, you are. So he really, I just didn't think his testimony was helpful at all. I mean, he talked about it looked like it had been repaired before, but then again, when he was cross-examined pretty vigorously, he just basically kind of gave up and said, I really can't tell when this was done. There are other ways that, drywall can come down. I mean, you certainly can hit it, it can come down. It's not just water. I mean, I think the plaintiff says, oh, it could only be by water. It can only be because there was, water coming from a flat roof. And I think that's the whole point, is that they still haven't quite made that causal link between the water on a roof and this particular incident. And it has to be particular. They have to prove their case. They can't just take a broad stroke and say, oh, there was water and they would put sealant on it, which fixed it, by the way. So therefore, this had to have been the cause. I mean, that's not enough. I just don't think they have quite gotten it over the goal line to get this case to a jury, Your Honor. Or maybe given the month, I should say, they haven't quite put that basket in at the buzzer.
Yes.
I think it falls a little short.
I'm trying to find, and I may just be missing it, their transcripts.
Your Honor, I asked that they be filed and they hadn't been.
Okay,
I brought copies,
I have,
but it's
so
up to
you
them to e-file the transcripts to the
I only
deposition.
have one original.
Okay.
Approach.
well, what we do is you certainly can approach. What I was gonna say is we have you file the, okay, so.
That's the only original we were ever given.
All right, so here's what we'll do then. I've got a sealed copy here. I'm actually going to, let's do this. Ms. LaRoche, I'm gonna pass this back to you, and I'm gonna have you keep this in your possession. If we
Okay.
have to have a trial, you can bring it. I'll theatrically open it for you in front of the jury. It's one of the best parts of my job. In the meantime, though, I'm gonna have you have one of your team members e-file the PDF versions with the clerk of our two experts.
Mike and, okay, you filed, okay. Yeah, I
And,
need to get that done Probably by the end of the day, he filed.
Yeah, I mean, if you need me to open the original, it's fine, but he's just
No.
giving me a,
Mike Dunn and.
and I'll keep these just for me to look through in the meantime. But I'm gonna use the PDFs in making my final decision, if that makes sense. So I'll use these as a stopgap. And once the PDFs get filed, I'll use those for the official decision.
Would
that
you
work?
like a courtesy copy attached to an email or? just
No,
when
as soon as
file?
you file it, I'll see it.
Okay.
So our clerk's really good at
Perfect.
letting us know what's there. So, okay, well, I'm gonna hold these just, for now, and thank you, Mr. Edwards, for these. And then once you all e-file them, they'll be there. So we're- Oh, okay. Mr. Hope would love a courtesy copy. He gets to make his own independent decision. He is not subject to my decision on that. So, okay, then, let's jump into these experts, because I do have a bench trial lined up behind y'all, so. All right, so we talked a little bit about Mr. Dunn, is it Caballero? Caballero. What else do you all want me to factor in to the 702 factors regarding these two? Or what do you want me to from your briefs? Any additional argument, or are you all satisfied with your briefs? Y'all are excellent briefers, by the way.
I was gonna say,
both
yeah,
sides
I
are
love
great
my
at this.
brief, because I would honestly just be kind of rereading my
Yeah.
brief.
Y'all, I mean, that's the beauty of this situation is y'all are very good at briefing things, and I'm very grateful for that, by the way. Because y'all are really good about laying it out in a very, very succinct manner, in an organized way, and I'm grateful to that for both sides. I love it when folks come in and give me stuff that I can actually read and follow and feel like I got it. So, if you're comfortable with that, and then I'm very comfortable looking at the motions for the 702 for the Mr. Mike Dunn for the roof and Mr. Isidoro, Isidro, and then Caballero, Cadallero. If you all don't have any argument, I'm gonna see if Mr. Edwards wants to make any. Y'all are good?
Yeah,
I mean,
we're liable.
Yeah.
All right, defense is good on Grace. Mr. Edwards, if you want to point anything out to me, I'm happy to hear it on the 702 motions for your experts.
Right, and this is tangential to that, but it is related to that. They also filed a motion to strike Mr. Dunn's affidavit, which was filed in response to their motion to exclude. I would point out, one, that we have the burden, as the plaintiff has the burden of showing that he is a proper expert, that we notified them of the opinion that's set forth in his affidavit. They didn't ask him about it. It was part of the disclosure when we disclosed him as an expert, that one of his opinions would be about the testing that was done. But in conjunction with that, his affidavit is also responsive to the motion for summary judgment. And that is another reason for it to be admissible. Beyond that, Your Honor, I would just, since I sat in on that seminar at lunch, I would just point out a couple of things very briefly, and I think they're covered well in my brief, but Mr. Dunn and Mr. Caballero both have very limited roles, but they're very relevant to facts that are at issue in the case. One is for Mr. Dunn about the flat roof and the materials that are put on there, and contrary to what Ms. LaVore says, he is very familiar with the types of sealant that were being used, the kind you get at Home Depot and Lowe's. He knows about these. He has spent years dealing with these, selling sealants and the whole bit. He has much training, which is set forth in his CV. So his qualifications directly fit this case. He's dealt with flat roofs, he's dealt with concrete roofs, he's dealt with water tests, he's dealt with sealants. He has nothing to do with the ceiling falling on Ms. Murphy or what she was doing when it happened or anything like that. Those are not germane to his opinions. What he can tell from the pictures, and he can tell because he is expert and he's seen it, is that the sealant delaminated, that there are cracks in it, that it's holding water. He knows about concrete. Concrete develops cracks. It's going to eventually lead to leaking. And if you're reporting a leak inside the building and the roof is like that, there's a connection, easily drawn. And bear in mind, our standard of proof is more likely than not. Mr. Caballero is coming from the inside. He knows about sheetrock. His qualifications fit the case in that regard. He knows about sheetrock repair. He knows about water damage to sheetrock. He knows about mold on sheetrock. He knows that it takes a long period of time. You can't tell how long, and that's part of the problem that RMA has. You don't know when it's going to fall. You can't tell, but you know the signs. You've got a bubble with water in it. You've got tape that's starting to separate, shows what looks like a crack, but it's just the water in the seam pushing down on the tape. You've got dripping on the floor. The connections are there, and he can testify to that. He also knows what a repaired section looks like, so he can do that. So we have all of that tied together. These are not scientists. They're not brought in for scientific theories or testing or anything. So the fact that they didn't perform tests or do examinations, like I say, I mean, it wasn't possible for them to do an examination. The ceiling and the roof had been repaired long before the case was even filed. Even though it's clear that Ms. Murphy told them she was going to go see a lawyer. They knew that before they even fixed the roof or the ceiling. So again, there's some echo back in the back of my mind about, spoliation that should keep them from making that kind of an argument. So they're not scientists, but they have the type of expertise for their areas that is germane to the case. Their opinions are reasonable, they're not outlandish, and they're reasonably applied to the facts of the case.
Okay, thank you. And obviously, having just gotten their transcripts, I will need to read each. So y'all already figured this out, but I'm taking all of this under advisement.
Right. I'm sorry, Your Honor. In that regard, I would ask you to, with Mr. Caballero's deposition, there's discussion on pages 33 through 48 where he pretty much lays out what I just told you and the questions and back and forth. And there is a point there where he says, well, what do you think to Ms. LaForest? But that's after he's gone through explaining, this is water damage, this is why this fell, this is what mold, da. And she's like, well, how do you know? And he's like, kind of, well, what do you think it is? I mean, he's never been an expert before, so he doesn't know how to play the game, quote unquote, but he is straightforward about what his opinions are. And it's more likely than not that this was a repaired section and that it fell because of water damage. And I think he says that very clearly.
Okay, thank you. Starting on page 33, and I'll read the whole thing, but I'll take note. Okay, anything else you all want me to take note? So y'all's homework is, on this one so far, is for the defense to get these two e-filed. Because I'd like to have them searchable where I can search for stuff. All right, there was one more thing. Oh, then the late thing. So what else do we need to address today while we're all in the same room together?
I'm prepared to talk about that, and interestingly enough, there was a Supreme Court decision that just came down. And it's not exactly about the 3-day rule, but it's 100% about e-filing being emailed.
I have not read this case. The case that's been handed to me is Birch versus Marta, B-U-R-C-H. It's a very new case, February 10th, 2023. A 22A 1655. And I will have to read it.
No, I just wrote this case.
All right, let's go off record real quick. I just want to make sure I don't miss anything. So sorry about that, y'all. I want to reach this on the merits, and I'm aware of the question, and I'm aware of the deadline, and you all have done such a great job getting this to me, frankly, in the way that I wish other lawyers would get this to me, in a well-briefed, well-organized, frankly, well-argued fashion. And so, yes, I'm aware that I have it within my discretion to exclude it, but y'all have done such a good job getting this to me. I really want to make this decision on the merits, and I'm going to stick to it on the merits. So we don't have to argue about that. So anything else? Y'all talk, see if you have anything else. Mr. Edwards, if you have anything else.
No, Your Honor. Oh, yes, I do. I'm sorry. This was a question about mediation. When we were here last and we talked about it, I think the court said we did not need to mediate again, but it's in the case management order.
I believe it. I remember there was a case, I broke my rule and said no, but I don't remember which one it was. Let's call it Franklin. Okay. All right, we'll go back on record, and I'll just simply say, as far as mediation, I'm gonna hold off on that one. Let me rule on these, see where we're at as far as working towards trial, and then I will let you all know with plenty of time to get there if I do want y'all to go back. So I'm not gonna surprise you and say, surprise you got 10 days to find a mediator. So we'll communicate that once I issue the rulings on these three issues.
And it sounded from this morning like the earliest we'd be on a trial calendar is August. Is that?
Yeah, so you have an earlier spot?
We didn't tell them that.
Was that them or was that a different case? We told somebody else they were on
Based on
August.
what you said to the other group.
Yeah.
Oh, yeah, no, they had a different procedural posture, so, but once I rule on this, that's when we'll say, this is where y'all are at.
You guys about 60 days, so you could very easily end up in the June calendar.
So,
Possibly June.
I am gonna be looking for, proposed orders from you all, so, and so if you all will, 30 days sufficient to get those?
I would put you on August.
Oh, well, that's exactly what happened. You feel comfortable typing?
No, that's fine.
Okay.
There's no reason there.
August it is. So 30 days, that will push you to August. I would like orders on both issues from you all, word format. Today's the 17th, so April 17th is the Monday.
Do you want separate orders, Your Honor?
Yes, so and word format. And like I said, you're welcome to send them earlier than 30 days. But just please don't send it later than 30 days. And again, it's on the motion for summary judgment, and then you can send one order on both experts. So 2 orders altogether, one for the motion for summary judgment, and then one for the motion to exclude both experts.
What about the motion to strike?
And the motion is-
You think it just easier for one? Yeah, he's saying what I was thinking. I was saying it, you know what, these things are so intertwined. I was sitting here thinking, and he was nudging me, and I was wrong. Let's do one, because they're so intertwined. So, yeah,
I don't think so.
so, because it's the connection, let's go for it. sorry, on my paperwork, y'all are swapped.
Yeah, we're a little mixed up because this is an appeal.
That's all right. So, and that's what I just realized when I sat down that I was, because you never sit over there and you very rarely sit over there. And so everybody's in the seats that they should be, but the paperwork is swapped. So, okay, great. Totally back on the same page then. All right, Plaintiff Freddie?
Yes, sir.
Before we begin, Your Honor, can we invoke the rule?
Okay. All right, so your client stays. If y'all will step out, don't talk about the case, and we'll get y'all in just a bit. And my understanding is you all do not wish for this to be taken down, is that correct?
That's correct.
Yes, Your Honor.
All right, Kathy, you're off the hook.
Yes, sir.
Perfect.
Dodge the bullet.
And again, I apologize, y'all, I ran a little long. All right, so, this is the bench trial. You all were on the jury trial calendar last time. Is this the one where plaintiff missed the deposition, and I said I would deal with that?
Mediation.
Mediation. And I
Yes,
said
sir.
we'll deal with that trial. Okay, so that's still on the table. We'll deal with that at the end of the trial. Is there any other housekeeping we need to address before I yield the floor to Mr. Harding?
I don't believe so, Your Honor.
I have a few videos. They're short.
Okay.
I think I'm plugged in. I don't know.
Yep, let's test it. Now's the time.
So I figured I'd mention it.
All right, is your computer on and plugged in and something on the screen?
Yes.
Okay. Okay, it says Cisco. I'm just gonna reboot it and then we'll keep going. That's fixed it on